There are black holes in the space. Bananas grow on tree. Bulls get angry when they see red color. George Washington had a wooden teeth. You drink water at least 8 glasses of every day. Dogs can only see in black and white. You believed all the facts are correct, don't you? Do tell me one thing. Do you also believe that we have 5 senses? Well, I know the answer, which is yes. Congratulations, you are absolutely incorrect. We are made to believe in such things. We accept them naively without giving a second thought. These are omnipresent. We call them myth. Hi everyone, this is Dr. Shweta and I'm back with another video on patent myth. What are the myths prevailing in the patent industries? Myths are direct result of little information, and little information, my friend, can be always risky. There are many patent myths that seems to be floating around among researchers, investors, CEOs, founders and academicians. And today I have decided to debunk 10 of these myths that I have found to be common among the decision makers out there. If any of them is holding you back, then now is a great time to break free from the chain and look at the patents from whole new perspective. But before we start, please like this video and do share in your network if you find it worthfully. And those who are new to my channel, I would request do not forget to subscribe it. Myth number 1. You cannot patent what is already existing or existing technologies. The fact is, at the first thought, an inventor might think that his innovation is mere improvement or already a patented technology. Hence, the invention is not patentable. However, if you give a closer look, he can patent a new usage of the existing technology as long as the usage is non-obvious, or he can also improve or modify the existing technology. An inventor can also obtain patents if the invention is combination of existing patented products. However, the combination should be non-obvious. He can also patent a similar product as long as the differences between the product are not obvious to a person skilled in that art. Or you can say there should be technological advancement from the prior art. Myth 2. Patent protect the inventions across the globe, or there is a term called worldwide patent. The fact is, people generally assume once they patent an invention, the patent stands valid worldwide. The truth is, patents are limited within a country. The inventor can protect the patent only in countries for which he has filed for patent protection. For example, if you have filed a patent for a particular product in India, you cannot interfere if someone is using that product in Germany or China or US. However, inventor can file patent application under the Patent Corporation Treaty (PCT) to seek protection in around 153 countries through single application. Myth number 3. Only lawyers or LLB graduates can be part of patent industry. This is whole a false statement. Why? I myself is not an LLB first. I have done my master's in science and then have jumped into patent field. That means a patent lawyer, especially a patent lawyer, I would say, should have first a technical degree and then an LLB degree. That means this combination, the person who is dealing in patent should have the combination of techno-legal skill sets, technology plus legal skill sets. Myth number 4. Patent have a role only in legal proceedings. Many organizations tend to believe they can use patent only to identify infringers and claim the invention legally during the court proceedings. Often, they forget to recognize the impact patent can have on the market value of that organization. Organizations with a strong patent portfolio attract more investors due to their active research and development activities. Patented products also establishes trust among the consumers and thereby promotes product sales. Hence, the general perception that one can use patent only for legal proceeding is a myth. For individuals, they forget about the monetary value of their patent, which they can license, they can sell, or even they can do the technology transfer of it. If you want to know how the companies have made their patent portfolio and what are their market value right now, you can visit this video about patent portfolio and IP portfolio of these companies. Myth number 5, ideas are patentable. Though ideas are the basis of an invention, we cannot patent mere the concept or idea. Offices grant patent to our inventions such as process, machine, product or new compositions. For an invention to be patentable, one must be able to build the invention using the technology, or it should be an already built form. Mere ideas are not patentable. Ideas can be only provisionally filed to secure the priority date in those countries where there is system of first to file. Myth number 6. Filing patent application is arduous. Inventors often feel that filing a patent application is quite complicated. On contrary, patent filing is very methodical and comfortable if the inventor is aware of the process. Nowadays, patent filing procedures are easily accessible and available online. However, it is advisable to approach a patent expert when designing a patent claim or writing the specification or conducting a patent search. Myth number 7. Patent office requires a prototype during the filing of application. The fact is, patent office does not require any prototype during the application filing. In fact, at the time of grant hearing also, patent office only requires the prototype when they feel the patent is frivolous or false. If you have a product or process for which you want to file a patent, describe it in form number 2 according to Indian Patent Act and give the required details where the best practices of this invention is explained. Myth number 8. Publication of patent is a victory. Few inventors consider that a publication is half victory for the patent application, and I want to say, my dear inventors, patent office published the invention without examining it. So, anything you have written in your application will get published. Myth number 9. Patents are plagiarized. In patent, plagiarism is not checked, as it is done in your research publication which is published in different journals, because both research papers and articles and patents are two different things. Myth number 10, the last myth of the day. If the university address is mentioned in the application, the patent will be considered of university. This is a huge myth which I come across every day. Many of the universities' chairperson or dean research come to me and discuss that our address is mentioned on the address of the applicant, and the applicant is either the faculty or the students or any researchers. This is complete false. The application will be considered only if your name is mentioned in the applicant. The IP rights, the application belongs to the person who is the applicant of it. If your name is mentioned in the address, if your designation mentioned, if your address is mentioned somewhere, it doesn't mean that patent belongs to you. Simply, the applicant holds the IP right. Especially for the universities, colleges and institutions, especially in your accreditation and ranking, if your name is there in the applicant, then only it will be considered. So here we come to the end of 10 myths related to patent industries. Differentiating facts and myth is never easy. Businesses should have always a clear understanding of patent to prevent them from following misleading information. In extreme cases, blindly believing in such myth might incur a financial loss to a person or to the industry whom the IP belongs. Organizations can always seek advice, and I will say should always seek advice from trustworthy patent attorneys to debunk such myths and build a strong patent portfolio. So here comes the end of this video. I hope you have enjoyed it and many of the myths has been busted today. I would request to like and share this video, and also if you are new to this channel, please subscribe, and if you have any query related to patents, kindly comment in the comment section. We will get back to you. Thank you so much.